of tonight, this event we have, and our special speaker. And so we welcome all of you for taking the time, because it shows how invested we are in what's been happening and how we want to right it. So we feel very privileged to have the speaker that we have tonight. Anyway, I just want to tell you also that these events are complicated very often to put on. So I want to thank those who are involved in this. I've got a great team. Sherry Gillis is our GSRW webmaster, and Kaylee Kozmatsu, who is also our corresponding secretary, but also is a great tech support on these events. So we thank them. And I also am going to turn the evening over to my first and second VPs. The second VP is Karen Contreras, who is joining us tonight, and she's going to help with the, you've got a big fan there, Karen. And so she's going to help field the questions. She is second VP of membership. If I didn't say that, I meant to. So thank you, Karen, for helping. And Gretchen Cox, who is first VP in charge of programs. And she also is going to help with the questions, fielding them for our special speaker. But I was almost going to do the introduction myself, Gretchen. I'm sorry. I'm just so excited. But I'm going to turn the program now over to you to do a proper introduction. Thank you.
Thank you, President Janet, very much. Welcome, everybody. It's nice to have you all with us. And we're actually also very glad to have our special guest tonight, who I'm going to introduce in just a minute. Before we get to that, I would like to remind you all, please check to make sure you are all on mute so we don't have any interference from background noise. We will be having more special speakers and candidate Zooms coming up. Typically, in the past, we've gone dark during the summer, but not this year. There's just too much going on, and it's too important to keep everybody up to date on what's going on. So we will be announcing some new Zooms coming up very shortly, so keep an eye on your email. And again, just please mute yourselves. And if you have a question that comes to your mind for Dr. Eastman, please put it in the chat box, and we will go through all of the questions there after Dr. Eastman has finished his talk. Okay, so on to the fun stuff. I am so happy to be introducing our very special guest tonight, Dr. John Eastman. Dr. Eastman received his BA from the University of Dallas and his MA and PhD in government from Claremont Graduate School. He graduated from the University of Chicago Law School and earned his JD in 1995. Dr. Eastman served as a law clerk from 1996 to 97 for the Honorable Clarence Thomas in the U.S. Supreme Court. He then took a position with a law firm in Los Angeles. He began teaching at Chapman University in Orange in 1999 and was recognized there as Professor of the Year in 2002. And he served as the dean from 2007 to 2010. Dr. Eastman is the founding director of the Claremont Institute Center for Constitutional Jurisprudence. He's a senior fellow of the Claremont Institute, and until January 2021, he served as the Henry Salvatori Professor of Law and Community Service at Chapman University's Dale E. Fowler School of Law. He has received numerous awards and recognitions over the years, almost too many to name. He has also written many books and has many scholarly publications. He's been invited to speak to congressional committees on numerous topics, including President Obama's executive order on immigration and the IRS's felonious disclosure of tax returns. So he's gotten involved in a lot of interesting cases. He has represented 17 parties in front of the U.S. Supreme Court. He has appeared on just about every news network, and his commentaries and writings appear in many national publications. And you can get all the details of all the different writings and the programs and his many accolades if you look at his full bio at the Claremont Institute website. We are so honored to have this very distinguished guest tonight. Welcome, Dr. John Eastman.
Well, thank you very much, Gretchen, and all of you for inviting me to participate, and for those of you that have joined. When in late November, I got a call from the White House switchboard saying, "Would you please hold for a call from the president?" I thought it was an old college buddy of mine pulling a prank on me, and the switchboard operator said, "No, it really is the president." And he got on the phone and said, "I'd like you to represent me before the Supreme Court, as this case is heading to the Supreme Court. We want to do an original action." That would normally be considered the capstone of a legal career, to be not only to be representing anybody in the Supreme Court, but the president of the United States. And my daughter thought it was a big deal. She took the brief we filed on behalf of President Trump. I filed a motion to intervene on his behalf in the Texas versus Pennsylvania case. She framed it and gave it to me for Christmas that year. It still adorns my bookcase at home. But as the old movie line goes, a funny little thing happened on the way to the forum. If you remember that old movie, Sid Caesar, I think. A funny thing did indeed happen on the way to the forum. What I will call the unip party in this country has decided that there wasn't anything wrong with the election. Bill Barr, the former attorney general, famously went on CBS or ABC News, I forget, in early December 2020, saying that they'd done investigations and they found no evidence of fraud significant enough to have overturned the election. There were two very important telling things about that statement. One, he didn't speak at all about illegality in the conduct of election, which I'll spend a great deal of time focusing on today. And he also said that they had done investigations. We know that that was not true. They did not do any substantial investigations or any at all. In fact, somebody filed a bunch of Freedom of Information Act requests asking for all the materials from those investigations he claimed to have done. They filed those requests with all of this U.S. attorney's offices in the swing states and the Maine Department of Justice. Now, investigative materials are exempt from the Freedom of Information Act. But if you've got such materials, your response to the FOIA request has to be, we have these materials, but they are exempt under the relevant subsection. The response that these chap that filed these FOIA requests got back from every one of these offices was there are no responsive documents. In other words, the claim that they had all these and done all these investigations was not true. The other thing that one of the government officials said was that this was the most secure election in our nation's history. That there was no evidence that any votes had been flipped. And when he made that statement, we already had evidence in Antrim County, Michigan, that votes that were cast for Trump had been recorded as being cast for Biden because of an error in the software update that had occurred in that state. So it was false when the statement was made, and it's become increasingly false on a lot of other fronts as well, as additional forensic audits of the equipment have been conducted in Georgia and in Colorado. But I want to focus on that other piece about the Bill Barr statement. He ignored the fact, he didn't say anything about the illegality that occurred. And this was largely my focus at the time as part of a hobnob team of lawyers working in various parts of the country to try and do something about what we were all seeing with our own eyes, glaring statistical anomalies that cried out for investigation. And my part was to focus on the illegalities that occurred. And let me set this up with the constitutional question, because it's important to understand the constitutional provision at play here in order to understand the illegalities. Article 2 of the federal Constitution expressly delegates to the states the power to choose president electors in the manner directed by the state legislature. And that's crucial. In fact, for the first half century of our nation's history, the state legislatures chose electors themselves. After the Civil War, every state has now adopted popular election for choosing the electors. But what that means is the election code becomes the manner directed by the legislature for choosing those electors. And if the election code is ignored or violated, then you don't have a valid election because you've got an election that was not conducted in the manner chosen by the legislature. And we had that happen in every one of the swing states and numerous occasions. And a couple of examples. In the spring of 2020, in a lawsuit filed by various Democrat affiliated organizations down in Georgia, the Secretary of State of Georgia entered into a consent decree, pretty dramatically altering the statutory signature verification process in Georgia, greatly weakening it. He did not have any constitutional authority to do that because only the legislature of Georgia could make such a change. And he did not present the settlement agreement to the state legislature for ratification or approval. They also authorized with outside money the creation of portable precincts, what I call porta potty precincts. They had a bus go around to various parts of Atlanta collecting ballots. That was in violation of state law on a number of fronts. The obligation to specify certain fixed places for precincts, to give advance notice of that. The reason all those things are there is so that the parties and the candidates can have their observers go to the precinct to make sure nothing untoward is occurring, that ballots aren't being slipped into the system. That became very hard, if not impossible, to do with these portable precincts. So that's just Georgia and just a couple of the front ends. I'll get more to the evidence that we've learned since then about Georgia later. But I want to focus right now just on the laws that were changed without constitutional authority. In Pennsylvania, in August of 2020, there was a lawsuit filed by the League of Women Voters. They purport to be nonpartisan, but that's not the case. They're very closely aligned with the Democrat Party. They filed a lawsuit against the Secretary of the Commonwealth of Pennsylvania. The basis of the lawsuit was that the signature verification process in Pennsylvania that did not allow voters to be notified if their ballots were disqualified because the signatures didn't match, violated federal due process requirements. And so the purpose of the lawsuit was to get the federal court to order those due process requirements to be complied with, that they have to give the voter notice that the ballot was being disqualified, and have to give the voter an opportunity to cure or to basically confirm that in fact the ballot was submitted by the person that it purports to be, even though the signatures did not match. The Secretary of the Commonwealth, instead of defending against that lawsuit, decided on her own, well, I don't think we have any signature verification process in this state at all, and I'm just going to unilaterally get rid of any signature verification. That overturned about 100 years worth of statutory signature verification authority in the state without legislative authority or approval. She then filed an action in the Pennsylvania Supreme Court, which is a partisan elected court, asking them to ratify her decision. It was called a King's Bench warrant, is the name of the pleading she filed, asking the Pennsylvania Supreme Court to confirm what she had done. I've often said if I ever run into her in the street, I will tell her maybe you should rewrite the name of that pleading, because you haven't had a king in Pennsylvania since 1976. A little bit dated to call it a King's Bench warrant. In any event, the partisan elected Pennsylvania Supreme Court obliged and said, yeah, we agree there's no signature verification process in Pennsylvania. And all those statutes on the books that describe how to do signature verification, well, those are just archaic remnants from a bygone day, and we don't need to pay any attention to them. And they got rid of signature verification. Now, the significance of that is that the disqualification rates in Pennsylvania declined dramatically as a result, because they weren't doing signature verification. Now, why is signature verification important? Well, if you're not checking IDs and you're not having witnesses sign the absentee ballot applications that are coming in and what have you, this is the sole way to confirm that the ballot that's coming in is from the voter who it purports to be coming in from. And if you get rid of signature verification, we're not talking about things that are a little bit off because somebody has gotten old and the signature doesn't look like it did when they were young. We're talking about things that are so dramatically different from the signature on file that it's clearly not the same person submitting this ballot, a pretty significant indication of fraud. And when those ballots don't get disqualified, you are now letting illegal ballots in and disenfranchising people who cast legal ballots. And yet that occurred in Pennsylvania to a great extent. We had other things going on in Pennsylvania. There's a 100-year-old statute in Pennsylvania, and maybe 112, 118. I don't know the exact number of years it's been in place, but it said the campaigns and the candidates are allowed to have observers in the room when the ballots are being counted. Now that was written at a time where in the room meant in the the little community room at the local library where your local precinct ballot counting was occurring. It was not anticipated that it would occur in something 2 football fields in size in the Philadelphia Convention Center. And in the room, they were only allowed to be within the first 5 feet inside the door. They were in the room, but completely pointless for the purpose of that statute, which was to allow meaningful observation, to ensure that signature verification was going on, to ensure that when people were adjudicating hard to read ballots, that the replacement ballots were actually being marked in the same way that the original ballot was. All of these things that observers are supposed to be there to do became impossible. So those are just some of the things in Pennsylvania that occurred. To this day, there are 120,000 more ballots that were cast and counted in Pennsylvania than their election systems show voters that were casting ballots. In my California bar proceeding, the Deputy Secretary of State said, well, you're just wrong about that. You're using the wrong data. You're using our SURE system, which is the voter rolls, for that purpose. But that's a dynamic database. People have been dropped off the rolls since November of 2020. So that number of people showing as having cast ballots will be lower because people died or people moved out of state. And that's true. But we also had a rebuttal witness that the California Bar Court refused to let me call, that was going to point out that in the time between November and when the updates to the voter rolls were finally finished in February of 2021, only 16,000 people had been removed from the voter rolls. So, it's high math, I know, but 120,000 minus 16,000 is 104,000. That's still larger than the 80,000 vote margin in that state. And it raises rather significant questions that should have been addressed. Let me go over to Wisconsin for a moment. This is the one where the number of illegalities was so clear cut and clearly more than the 20,500 vote margin in that state. The first thing was a couple of county clerks in heavily Democrat areas advised their voters that they could ignore a state law for mail-in ballots that required that they submit their voter identification, a copy of their identification with the ballot, if they claimed that they were afraid of COVID and therefore indefinitely confined. The statute quite specifically describes what qualifies as indefinitely confined, and fear of going outside is not one of the requirements. It's not one of the things that qualifies. The reason this is so significant is the number of people that claimed indefinitely confined status and did not have to submit identification with their absentee ballot skyrocketed from about 50,000 in 2016 to over 250,000 in 2020. Why is that important? Well, because voter ID is one of the ways that you try and prevent fraud in the part of the election system that is most susceptible to fraud, and that's mail-in ballots. Those 2 county clerks got rid of it. The courts held that that was illegal, but the damage had already been done. Another thing that they did in Wisconsin, it's required that a witness sign under oath your outer ballot, confirming that they know the person that has filled in the ballot and that the person is who the outer envelope says it is. And that witness is supposed to put their name and their address and then sign it under penalty of perjury. Well, a lot of these ballots were in the county clerk's offices, again, in these heavily Democrat cities in Wisconsin. And the the county clerks directed their employees to Google search the names if they didn't have their address. And they were doctoring the outer envelopes, doctoring the evidence in order to make an invalid ballot valid. The election law in Wisconsin is very clear. Ballots that come in without the required information, quote, shall not be counted. There's no discretion about it. They can't be counted. They are illegal ballots, and they were counted extensively in heavily Democrat areas. Another thing they came up with that has subsequently been held to be unconstitutional in violation of state election law. They created drop boxes with Zuckerberg money, and therefore they created them in heavily Democrat areas. Zuckerberg's folks have claimed that, well, they made grants to Republican and Democrat counties. That's true, but about 90 or 95% of all the money went to heavily Democrat counties. You know, if you give $3 million to Philadelphia and $500 to a Republican county out in the sticks someplace, that's not an equal ballot harvesting operation. I'll get back to that in a minute, but these drop boxes were held later to be illegal under Wisconsin law, and therefore, when we're talking about presidential elections, an unconstitutional usurpation of the legislature's power to direct the manner for choosing presidential electors. They even went further than that, though, and they created a program called Democracy in the Park. Democracy in Park utilized what they called human drop boxes. These were, I suspect, Biden volunteers who were deputized to go out and collect ballots in the park outside of University of Wisconsin to gather up as many of those likely Democrat voters from the college campus as they could. That was double illegal. It was, you know, drop boxes are not legal, and human drop boxes even further not illegal. That one operation collected 17,500 ballots illegally in a state where the margin was 20,500. After the fact, we subsequently learned about an even greater scandal. The Secretary of State had prohibited bipartisan teams. The state law requires to go into nursing homes before ballots can be collected in nursing homes. Why is that important? Why is that law in the books? Because people in nursing homes are particularly susceptible to undue influence. And this law is designed to prevent undue influence from people going in and encouraging folks in nursing homes to vote one way or the other, whether they wanted to or not. The Secretary of the State prohibited those bipartisan teams from going into nursing homes in violation of state law. She did it because she said it was because of COVID, but the legislature had met and they did not make this adjustment in the state law to deal with COVID. So she's doing this on her own, unconstitutionally. The fish tank cleaners were still allowed to go into the nursing homes and do their work, but the ballot collector teams, the bipartisan teams, were not allowed. That's a illegal action that opened the door for fraud, and we now know for a fact that people walked through the door and committed fraud. How do we know that? Well, Justice Mike Gableman, former Supreme Court justice on the Wisconsin Supreme Court, was retained by the Wisconsin legislature to conduct an investigation. And one of the things he uncovered was this nursing home scandal. And what he learned during the course of his investigation was that turnout rates in the nursing homes went from roughly 20 to 30% on historical average to nearly 100%, including in memory care wings in the nursing homes. And many of the ballots were in the same handwriting. In other words, people that tell you there's no evidence of fraud, this is the most visible evidence of fraud that we have. And it was far in excess, when you look at it statewide, far in excess of the 20,500 vote in Wisconsin margin in Wisconsin. So those are the kind of things we were dealing with. There are other things that they did up there as well. And the Wisconsin Supreme Court refused to hear these cases at the time. But after the fact, 2 years later, in a case called Tigan, it held that, in fact, these things were unconstitutional. And so we now know that. And let me shift over to Michigan. I'm not as familiar with all the various laws that were violated in Michigan, but there are some very good people up there that were on top of this. And I want to use Michigan, though, as part of a broader story. One of the things that happened in this election that had not been done before was the creation of central counting facilities in large cities, in Philadelphia, in Detroit, in Atlanta. What, if for any of those of you that have been involved in elections before, well, what normally happens? Well, you get two groups of ballots. You get people that vote in person, and you get people that vote by mail. Oftentimes military who are overseas, or people that are traveling, depending on what the state's laws are that gives people the right to vote by mail. Those mail-in ballots get sent to the precincts, where they are counted alongside the in-person votes and reported up to the county, accumulated, and then appointed up to the Secretary of State to be reported. Well, that didn't happen this time. In these big cities, all of the precincts in the county were brought together into a single counting facility. The significance of this is it's a little hard to sneak in 35,000 ballots and hide them in a precinct where there's only 1,200 people voting. Much easier to do it in a county-wide central counting facility. So if there was injections of illegal ballots that were going to occur, putting it into a central counting facility made that easier. The fact that there are more votes than voters in Pennsylvania strongly suggests that, in fact, something like that is exactly what happened. In Georgia, one of the things that we have learned from an audit in a case down in Georgia that is still pending, the case name is Garland Favorito versus Raffensperger. And there was about a week when the judge in that case granted their discovery request and gave them access to conduct a forensic audit of one of the machines in Fulton County. And what they discovered in that brief window before the judge retracted his order was astounding. This is a little detailed, but it's extremely important because I think it's proof beyond doubt. In Fulton County, there are 490 precincts. And think about just the logistics of managing and scanning and counting those ballots, because every precinct has different races on the ballot. Every precinct has different city council races, different school board races, different local initiatives. So each ballot has a code that tells the scanning machines which key to look to when they're deciding how to count the bubbles on that ballot. If there are 490 precincts and they're putting batches of 100 ballots together through the machines at a time, that number, that the odds that number, that ordering, that digital sequencing of those ballots is 100 to the 490th power. It's an unbelievably large number, which means it's an infinitesimally small chance that any set of 100 ballots is going to be in exactly the same order as any other set. It's impossible. And yet in that 1 week, they discovered 5,000 ballots that were in batches that were in identical order. Completely impossible unless somebody is either scanning the ballots, the same batch multiple times and having them counted multiple times. And this gives some credence to the video, the State Farm Arena video that we saw, where that appears to have been going on. Or somebody is replicating the ballot images in the machine and having them counted multiple times. And with the evidence we have that may have occurred as well comes in the various recounts. How many of you have heard, well, they did 3 different recounts and audits in Georgia, and they all came up with Biden winning? Well, that's not quite true. They weren't audits, they were recounts. And in fact, the recount in Fulton County came up 17,000 short at the deadline when they had to report. And magically overnight, they found the 17,000 ballots. Well, guess what? If those ballots had been replicated in ballot images and then counted, as this forensic audit it demonstrated something like that had happened, and then all of a sudden they have to go find out of a closet an extra 17,000 ballots to make it reconcile, this is something that really cried out for further investigation that never occurred. So these were the kind of things that we were dealing with. And they were bringing court challenges, and the courts were almost uniformly refusing to hear them. And you've probably all heard the standard line, well, 65 cases looked at these things and rejected Trump's claims in every one. I mean, that's just not true. In most of those cases, the courts did not address the merits in any definitive way. They dismissed the cases on various procedural technical grounds, some correct, some completely specious. And I'll give you an example, a very important example. I forget which state it was, Wisconsin or Michigan, I believe. There was a directive that came out of the Secretary of State's office that was clearly contrary to state law. So before the election, a lawsuit was brought challenging the directive, and the court dismissed the suit because the directive was described as a guidance and therefore not binding. And until the county clerks actually followed the guidance on election day, the case was not right. We didn't know there was going to be illegality if people were going to. We didn't know whether people were actually going to follow the illegal guidance or not. So the case was dismissed, not ripe. In fact, the county clerks, in fact, followed the guidance, violated state law, and the lawsuit was brought again, and the case was kicked out on the ground of what's called laches. You can't wait till your guy loses. You can't sit on your rights. Wait till your guy loses and bring the case. So it gets dismissed by bringing it before the election is too early, and gets dismissed when it was brought after the election is too late. These are the kind of things we were dealing with. Some of the cases, like I said, though, were properly dismissed on procedural grounds. Ordinary voters don't have standing to bring a lawsuit challenging an election result because they don't have a particularized injury. And the Supreme Court has said a particularized injury is required to have standing in federal court. But the candidates have particularized injury quite clearly. And a candidate in Pennsylvania, the Trump campaign and President Trump himself, brought a suit challenging illegality as a violation of the legislative authority given to the state legislature by the Constitution of the United States. And the court in that case, it's called Bognet, B-O-G-N-E-T, threw it out, saying the candidates don't have standing. Only the legislature had standing to protect its authority to pass the laws, even though this candidate was particularly impacted by the results of the illegal counting of votes in violation of the state election code. Now, a couple months ago, a bunch of state legislators in Pennsylvania sued President Biden because of his executive order basically deputizing federal government agencies to do a get out the vote operation for Democrats. And the court held there that only candidates have standing. The legislators don't have standing. So you see what we're dealing with here. By the way, a lot of this was going on while I was down with COVID. I had been in Philadelphia by chance the weekend after the election. I was at an academic conference. A friend of mine who was working on the campaign knew that I was there, and he mentioned it to Pam Bondi, who was working with the Trump legal team. And they asked me to come over and meet with the legal team because one of the major law firms in the country had just withdrawn from representing Trump, and they were scrambling to kind of put things together to bring these challenges. And so they asked me if I would come over and consult with them. I was there for all of 15 minutes before I got kicked out because somebody in charge didn't know who I was and thought I was throwing a wrench in the works. They wanted to get a press conference going and a complaint filed that afternoon, and I was making some recommendations on revising the complaint. In that 15 minutes, I caught COVID. Somebody else in the room had COVID, and I was down pretty badly for the next 3 weeks. I come out of that, and I felt like Rip Van Winkle. The world was different. All of these cases were running on the shoals and not getting anywhere. And it's at that point the president of the United States called me and asked me to get involved and whether there was something that could be done. And we settled on this idea for an original action. And I was concerned initially that the state of Texas or Louisiana or Missouri or whichever state was going to ultimately bring this action, challenging Pennsylvania and Georgia because election officials in those states didn't comply with the legislative rules set out by their state legislature. And it kind of didn't sit well with me that, say, Texas was going to complain that Pennsylvania legislature's powers were being usurped. Why didn't Pennsylvania rise up? But there's an old case from the 1980 election, Reagan versus Carter, and some of you may remember that John Anderson was the third-party candidate in that race. And in Ohio, he was blocked from getting on the ballot. And a lawsuit was brought against Ohio election officials, saying that that affects voters all over the country. One of the plaintiffs in that case was a voter from New Jersey. And the Supreme Court upheld their standing to bring that suit because the office of president is a national office. And if unconstitutional constraints on ballot access in one state can affect the ability of voters in another state to choose the president of their liking, then they have standing to bring that suit. And I thought that was a very strong argument that warranted standing. And so I shifted my position and ended up agreeing that that case should be brought. The Supreme Court ended up dismissing the case 4 days after it was filed with a one-line order saying they don't have standing, without ever explaining away its prior decision in Anderson versus Calabresi. Anyway, it was in that case that I filed a motion to intervene on behalf of the president. And under Supreme Court rules, a lawyer that files a brief has to put on the front cover of the brief their name, their business address, their email, and their phone. And I all of a sudden became the one lawyer that people in the world over had an email for. And you can imagine what my life became like after that, quite apart from all the crazy, nasty hate email I got, which was rather pronounced. I also became the recipient of election information from everybody that thought they had something that they'd seen that they wanted somebody to do something about. Some of it was crazy. Some of it was credible, but very hard to prove. Some of it was credible and easy enough to prove with the time we had that we started looking at some of these things. And I had a team of statistical experts that I was working with that were identifying huge statistical anomalies in key counties in the swing states that warranted further investigation. I had just all sorts of information, and there's no question in my mind that the number of illegal votes clearly exceeded the margins of victory in each one of the swing states. Whether those illegal votes also were fraudulent votes is much more difficult to prove. But as I mentioned earlier, in Wisconsin, in the context of the nursing home scandal, I think we proved it. In Georgia, with Garland Favorito's forensic audit, I think we've proved it. The number of ballots exceeding the number of voters in Pennsylvania, I think we proved it. By the way, the Pennsylvania Secretary of State has to this day a false statement supposedly debunking that claim up on her website. She says the number of votes that were cast was lower than we claim. Well, she only counts the number of voters for the three major candidates, Trump, Biden, and Jorgensen. She doesn't count the overvotes. She doesn't count the undervotes. These are votes that were cast but couldn't be counted because overvotes, that were 2 people were counted or more. Undervotes, nobody was counted or more. She didn't count any of the votes that were counted in late. Those are votes that were cast by voters, but weren't counted. And so she's just blatantly lying on her own website to this day about why this story of more ballots than voters is not true. It is true. Anyway, these are the kinds of things we were dealing with. So now you get forward to the presidential electors. One of the things that became very clear to me as I was doing my research and all this, and my research on this didn't start with this election cycle. I was brought in to the Florida legislature in 2000 to give expert testimony about Florida electors and the role of the state legislatures in choosing and directing the manner for choosing presidential electors. I was an expert at that hearing, that famous hearing back in 2000. So I'd been looking at these things for quite a while. One of the things that becomes very clear, if you spend any time looking at the historical record of this, we have an electoral college because the founders did not want Congress having any role in the choosing of the president. This was not to be a parliamentary system like that exists in Great Britain. They designed instead a separation of powers system where the executive was separate from the legislature and separate from the judiciary. They did that by design, and they specifically precluded Congress from having any role in the choosing of the presidential electors. They gave that power initially to the state legislatures. And I'll talk a little bit about the vice president's role in resolving disputes in a minute. But it was, if you look at the federal record, the federal convention debates, it's absolutely clear they did not want Congress having any role. They did give Congress one duty, however, and that was to set the dates for having the election, and importantly, the date on which the electors would meet. And the Constitution requires that that date be the same throughout the United States. So you couldn't have rolling elections where people knew the outcome of the early states when their electors were voting, and then try and influence the electors in later states. Had to be the same throughout the state. So there's a serious question: if electors don't meet on the designated day and they're subsequently deemed to be the valid electors, could they be counted anyway if they hadn't met? Why do we know this is an important and unresolved question? In 1856, there was a blizzard in Wisconsin. And no, I wasn't there, but I've heard stories. My family's actually from the Wisconsin territory at the time. In fact, my great grandfather was named Charles Sumner Eastman, because the day the news that Charles Sumner had been attacked on the floor of the Senate for his anti-slavery position, the day the news of that reached the Wisconsin territory is the day my great-grandfather was born. And so they named him Charles Sumner Eastman. In any event, the blizzard prevented the electors from meeting on that day. They met the next day and cast their votes and sent them to Washington, D.C. The acting president of the Senate, there wasn't a vice president at the time, this office was vacant, but the acting president of the Senate, in the role that is normally filled by the president of the vice president of the United States, determined to count those votes. There were objections to him doing that, and he ruled the objections out of order, because the House and the Senate are there under the Constitution merely to be present, that it's the vice president's role to make such determinations. He then gavelled the session closed and announced that Mr. Buchanan had been elected president of the United States. For the next 3 days, the House and the Senate independently debate whether that was constitutional or not, whether the vice president or the acting president of the Senate had acted properly or improperly. And they were never able to resolve the debate. They ultimately tabled the question. It was not essential to the outcome of the election, those Wisconsin votes. And so they just punted. And to this day, we do not have an answer to that question. But I think there's a very compelling argument that if electors don't meet on the designated day and they're subsequently deemed to be the valid elected electors, that they cannot be counted because they didn't meet on that designated day. And that's why the electors in Georgia and Nevada and the other swing states all met on the designated day and cast votes. 2 of the states, Pennsylvania and New Mexico, specifically put in their certifications that their votes were contingent on the resolution in Trump's favor of still pending litigation. The others did not put those in the certificates, but they made clear that's what they were doing by their public statements recorded at the time they were casting those electoral votes. This, of course, is highly significant for the criminal indictments against electors in Georgia and in Arizona, the one that was filed this morning by the Attorney General in Wisconsin, and other ones that have been filed in Michigan and Nevada. All 5 states now, except for the 2 that put conditional language in their certificates. The other thing that's important about that is the language that was in those certificates was copied verbatim from the language of John Kennedy's elector Hawaii certificates in 1960. In 1960, Richard Nixon had been declared the winner of the election on Election Day. The acting governor of the state certified the Nixon electors. They met on the designated day and cast their votes. Just like in 2020, the Biden electors that were certified met and cast their votes. But at the same time, because there was pending litigation, the Kennedy electors met and cast votes. And they put in their certificates that they were the duly elected and qualified electors from the state of Hawaii for John Kennedy. And they transmitted those votes to Washington, D.C. When the election challenge ended up resulting in a court determination that Kennedy had in fact won the election, The newly elected Democrat governor of Hawaii certified a third slate of electors, Kennedy electors, and rushed that certified slate to Washington, D.C. Richard Nixon, the vice president at the time, presiding over the joint session of Congress, opened all three slates of electors, and determined on his own to count the last one. In other words, he rejected the original certified slate of electors for himself. He rejected the uncertified initial slate of Kennedy electors, and he accepted the third slate of Kennedy electors. Again, that didn't matter to the outcome of the election. Texas and Illinois probably corruptly had determined that Kennedy had won, and that was enough. However, the Hawaii electors, but nevertheless, it's historical precedent for everything that occurred in 2020. So these kind of challenges then get to the joint session of Congress, as I mentioned earlier. The power under the 12th Amendment mimics the language under the original Constitution in Article 2. The vice president opens the certificates, quote, in the presence of the Senate and the House, and then the certificates get counted, or the votes get counted. There's serious scholarship that has been done on this that says that the House and the Senate are there to be present. In other words, what the vice president does has to be done in public. And that, for gentlemen at the time of the founding, was considered more than enough protection to prevent nefarious conduct by the vice president. But if there are multiple slates of electors, somebody has to make the judgment about which ones to be opened and counted. And as we know from the founding generation, the last group that they wanted to have any role in doing that would have been the Congress. Not a very good second best to say the vice president Pence, in his dear colleague letter on January 6th, said, I can't imagine the founders would have given such power to a single person. This though, from a convention that had just given an extraordinary power to run the entire executive branch and all of our foreign policy, and to be commander in chief of all of our armed forces to a single person in order to be hold that person accountable for anything that he did. So it's not out of the question that they had designed this thing for such disputes to be resolved by that single person. In any event, Pence declined. We all know what happened thereafter. And what we're seeing now is for anybody that dares to raise questions about the legitimacy of that election is being not just hounded out of society, but is being criminally prosecuted. If they're lawyers, they're being disbarred. If they're other people, they're being debanked. They're being, cut off from social media accounts because, and I'll close with this, and we'll open it up to questions. I have stated publicly that I think what we have done here is readopt something that our founders rejected from the Old English Common Law. There was an Old English Common Law called the law of seditious libel. If you criticized the government, you could be criminally prosecuted for seditious libel. And truth was not a defense, because the line was, the greater the truth, the greater the libel. If what you're saying is actually true about the government's misdeeds, that brings the government even into greater disrepute than if what you're saying is false. I believe that that's what we have effectively readopted here. Our First Amendment was designed in large part to prevent that from happening, and yet we are blowing through the First Amendment like a hot knife through butter. We're blowing through the Fourth Amendment. We're blowing through the Fifth Amendment, the Sixth Amendment's right to counsel, all of this in order to prevent somebody who, in my view, quite clearly won the 2020 election and is now the front runner of the election in 2024. So that's where I'll stop. That's kind of the full scope of what we were involved in and why we did what we did, but I'd be happy to take any questions.
Dr. Eastman, thank you so much. I'm going to start off the questions, and if you don't mind, I'd like to ask you to tell us briefly, because we do have a number of questions to get through, but what's going on specifically with you at this moment?
Well, so I'm unindicted co-conspirator number 2 in Jack Smith's Washington, D.C. indictment against President Trump. Jack Smith, by the way, who I think has no constitutional or legal authority to even be involved in prosecuting a case. He was not an officer of the government when he was appointed in this role, and therefore violates the Appointments Clause of the Constitution. It was not a presidential appointment. It was not a Senate confirmed appointment. It was not even an appointment by a department head of somebody who was authorized by statute to be appointed in that way. So that whole thing, in my view, should be thrown out. But I'm unindicted co-conspirator in that case. I'm indicted co-conspirator number 3 in the Georgia indictment against President Trump, and the electors, 19 total, 4 have now pled out. And then a month ago now, 5 weeks ago, I was named in the indictment handed down by the Attorney General of Arizona against the electors there, even though I had 0 communications with the electors in Arizona, 0 involvement with any of the election challenges in Arizona. And my speculation is because I continue to speak out publicly about illegality in the election, that I was named there just to send a message to anybody that doesn't want to, that might, be cowered away from standing up against future election problems. And then I underwent this past summer what one commentator described as the longest and most expensive bar disciplinary proceeding in history. It lasted 10 weeks, over 32 days. It already has cost me more than $750,000 in legal fees to defend against that full-fledged trial, where the basis of the claims against me were that I had no evidence for saying the things I did, and essentially because Bill Barr said the election was fine, and I said otherwise, I was lying, and therefore exhibiting moral turpitude that should disqualify me from being a lawyer. So you've just heard the presentation of the evidence. It's hard to say that this is not at least tenable basis for making the statements that I made or bringing the challenges that I brought. So that case is now up on appeal, and only the California Supreme Court can actually impose the discipline of disbarment or suspension. So we'll hope that they will faithfully apply the law and put an end to this before it's done. But it's got a ways to go yet. So that's what we're dealing with.
Okay, and I know you have a Give, Send, Go page. How does that work? Can you tell us? Do
Sure.
they just go to Give, Send, Go?
GiveSendGo.com/Eastman. The significance of that page is threefold. You can send donations there, and we're estimating between $3 and $4 million before all of the defense of these. I've been dealing with 18 different actions so far. Before it's all said and done, we expect to build the total tab will be about $4 million. We've raised about 900,000 on that site so far. So if you can go and contribute something, that would be terrific. There's also an address with a P.O. box at the top of the page where if you don't want to do an online donation, you can send a check through the P.O. box. The second thing important about that site is you can send us prayers. And we need them. My wife and I read them, particularly in the more troubling moments, and they are heartwarming and much appreciated. And the third thing that's important about that site is I do regular updates. Maybe every 3 or 4 weeks. 45 updates in the last 2.5 years, not a lot. But what I do with those updates is kind of give a little sliver of the most important things that are being written about what's going on, so that you can arm yourselves with information and get beyond the media false narratives that are being put out there. So use that as a blog of information that you can access as well. GiveSendGo.com/Eastman.
Thank you so much for that. I wanted to make sure we got that information out. So there's a question here that was submitted prior to the start of this Zoom tonight. And it's kind of a general question, but what is the best response to someone who states, I cannot vote for a convicted felon for president? President Trump supporters are willing to stand by our candidate. What would be, in your opinion, the most effective response? And frankly, we could use it for when we talk about you as well. What you haven't been convicted, of course, but when somebody says that about President Trump, what do you think is the best response?
I would just say, did you watch any of the trial? Do you understand what a sham this was? And just ask him, do you have any idea what felony they actually convicted him of? Because the judge's instructions The misrepresentation of business records is a misdemeanor whose statute of limitations ran about 5 years ago. He tied it to claims of that it was designed to hide a different crime, but they never did describe what that crime was. Could be federal election, could be, making false filings on other business records, but they didn't identify what they were. Could be tax problem, but they didn't identify what exactly it was. And the judge specifically instructed the jury the requirement for unanimous jury on every element of a crime, that they didn't need to agree on which other crime was involved. If they just, they all thought something was there. The federal election claim is patently false. But here's one of the grounds for reversal on appeal, one of the strongest grounds, I think. Motions in limine were filed. That's a motion to exclude evidence. The judge ruled in favor of the prosecution's evidence and against the evidence that Trump wanted to put in on the key question of whether the Federal Election Campaign Act had been violated. The evidence the prosecutors got to put in was the fact that Michael Cohen had entered a plea bargain admitting to violating federal election campaign law. Now, it turns out he didn't violate federal election campaign law, but that was the plea bargain he entered, and that was what the evidence was put in. Trump's lawyers wanted to put in the former chairman of the Federal Election Commission, an expert on election law, to tell people that, in fact, it was not a violation of federal election campaign laws. In fact, if President Trump had used campaign resources to make this payment, that would have been a violation of federal election law. But they were not allowed to put that in, and then the judge did not instruct the jury that this was not a violation of federal election law. He let that come to their conclusion when the only evidence they've got before them is that one of the key witnesses in the case had pled guilty to violating the Federal Election Campaign Act. That was an unbelievable violation of the president's due process rights and an abuse of the judge's discretion, and it tainted the jury beyond measure. So those, I just say, these things will be overturned on appeal. This was a sham trial. It was a show trial. It was a circus, and it was designed to prevent the leading candidate for president from being able to run for office and campaign. And we ought not to let our lawfare leftists in the country get away with that. That's how I would answer it.
That'll work. Karen, do you want to take one of the questions from the chat? We're almost out of time, but do you want to? You're muted.
By the way, while you're doing that,
Yep.
TomKlingenstein.com, Tom's the chairman of the board of the Claremont Institute, and he runs a very prominent article website. And on his website, as of this morning, is my commentary on the New York guilty verdict and trial.
Oh, great. Thank you. TomKlingenstein.com.
Yeah,
He's
I'll tell you,
terrific.
I'll put that link in the chat here while we're talking.
Wonderful.
Okay.
Great. All right. So Angie asks, what are the repercussions of sentencing President Trump 4 days before the Republican convention? I know it can be appealed. However, will the sentencing affect his candidacy for the presidency?
Well, being a convicted felon, not being a felon is not a qualification for running for president. And the Supreme Court has held that no state can add additional qualifications, so they can't prevent him from running. They can put him in prison and prevent him from campaigning. But I think what we will see is a series of letters from a Birmingham jail type of thing, letters from the Rikers prison, from the president campaigning from prison cell. You've also got a huge problem with Secret Service coverage. We never dealt with anything like this before. More importantly, this kind of charge, which, by the way, was manufactured in the first place. It was a misdemeanor. It would never get prison sentence. They tied it to some claim of another crime that nobody ever proved. This is not the kind of thing that would normally ever lead to prison at all. Hillary Clinton's team laundered hundreds of thousands, millions of dollars, I forget what the number is, through its law firm to pay for the hiring of a foreign agent to create this phony Russia collusion story in collusion with high officials in our own government. That was a violation of the campaign finance laws. She was fined over $100,000 for that, but nobody thought that this was a criminal matter to bring criminal charges. She's obviously not in prison for making that blatant violation of federal campaign law and misreporting it as legal expenses on the campaign finance reports instead of opposition research. So this is normally not anything that would lead to a prison sentence, even if the convictions were valid, which they're not. It would lead, particularly for a 77-year-old, probably to a fine or something of those sort. But what we see here is a blatant attempt to interfere with the election. So I don't hold out much hope that he's not going to get sentenced and taken away right on that day to a prison cell. It will be extraordinary. And the ramifications of that will play out for decades to come.
Is everybody okay? Doctor, do you have just time for maybe one or two more questions?
Sure. I'm sorry I went a little long. I didn't mean to.
That's
I didn't mean
okay.
to trigger the short circuit the question so much.
President Janet, is that okay with you? And is it okay with everybody else?
Absolutely, and we really
Okay.
appreciate the extra time he's giving us. This is a very, we're privileged to have him for this time.
I couldn't believe that we are already at that time. So it went so fast and my mind's gobsmacked. So my question that I'd like to ask is, with all of the issues that you've talked about, all of the unconstitutional behavior by all of these different agencies and judges and all of these different things, I keep wondering why isn't there any sort of a what's the word I'm looking for? Why isn't there anybody in place to stop these kinds of things? Why do we have to go through all of, yes, to make hold these people accountable, especially judges that like this guy in New York and all of that. I mean, for the whole country to have to go through this whole thing and wait until appeal and finally get to the Supreme Court, and for the not only all of us but the defendant, why isn't there something to prevent that?
Yes,
part of the problem is the left has been very systematic in taking control of the pressure points of all of the major institutions in the country. The Department of Justice, the FBI, the judiciary, the major media. This has been a systematic effort underway for a half a century, and we've been sitting on the sidelines, not paying much attention to it. We now can no longer avoid that it's going on, and I just hope it's not too late to fix it. But you're right. I mean, people need to be held accountable. Look, Hillary Clinton, while she was under subpoena, destroyed evidence on a private server that was hosting classified information. The server was set up to hide a pay-to-play scandal from the Clinton Foundation, so that wouldn't be going through the servers at the State Department. She sold out, most of our uranium stock to our principal enemy on the global stage at the time, Russia. And zero accountability. She did the thing with the hiring of the Russia collusion story, which everybody knew at the time was fake. And yet it occupied us for years. People that actually doctored evidence in order to get FISA warrants to spy on the opposing political campaign, and continue to spy on him after he was elected, and continue to spy on him after he was inaugurated. The only one that ever faced any consequence at all was the guy that actually doctored the FISA evidence, and he got a minor fine, and he's still practicing law. So until we have equal justice under the law, which means nobody gets charged with things that are made up versions of statutes, but that people that actually commit clearly established law violations be held accountable, then we no longer have a system of justice and the rule of law in this country. And task one for the new administration has to be to get that train back on the tracks and going in the right direction.
Yeah. Karen, excuse me, Gretchen, is it all right if Karen takes the last question, and then we will wrap it
really
up?
quickly? I just want to interject that I did put the link over in the chat to the Go
Give, Send, Go. Thank you.
Send, Go.
By the way, I'm looking at the chat and I just got to call out Gina. What a great response to the question about he's a convicted felon. Jesus was wrongly crucified and we still believe in him. And the founding fathers were all considered criminals in Great Britain, and yet they're heroes. That's a beautiful response.
Right.
Yeah.
It gives us such inspiration. Karen?
So yes, we have a question. How can we prevent the American Communist Party, i.e. the Democrat Party, from cheating again in 2024?
Right.
That's a great question. So two things. One, and where I draw optimism, so many people have been awakened to what went on in 2020 that they are getting more actively involved in their local election process than ever in our nation's history. Millions of eyes will be on that process in 2024. And it won't be just on election day. It will be early voting. It will be the submission of absentee ballots. It will be people signing up as observers. It will be people signing up as poll workers. You know, why just observe a poll worker violating the law? Why not be the poll worker yourself to ensure that you're faithfully complying with the law? Find out what your rules are in your state and your county, sign up for those positions and have eyes on. The second thing is, you know, the black box manipulation potential of election equipment. People are now aware that this thing is certainly a possibility and that our equipment is insecure, and they are watching it. And because people are watching, it's going to be much more difficult to manipulate things. And so, you know, that's the best I can say at this moment. Just get involved and watch. And when you see something, say something. Isn't that the line? Document it and work with a lawyer in your county to get it documented. Part of the problem with election challenges is they're very short time frame. And if you see something and it's not documented on the front end, 4 weeks later, when a lawyer gets involved and is trying to retrace what happened, it's too late. Get it documented right as you're seeing it. Talk to the lawyer. What kind of format does this need to be in to be admissible evidence that we can get before a court if it comes to that? And start thinking in those terms.
Oh, well, Dr. Eastman, I'm left speechless, but I am, everything you said, I have felt in my heart since the 16 election. I felt it was coming up then, but the lawfare that the left has now perfected in this country against us, the freedom-loving patriots, this is why we have to fight. And we are so privileged to have you as our champion, as our fighter for freedom and for President Trump.
Thank you very much. Let me close with just one story. Right before Christmas, they had to do a human interest story on me and my family. The purpose of which was to show how devastated we were. And I said, where are you getting that? Our country's on the precipice of losing freedoms we inherited from our forebears. And for whatever reason, I've been cast in the front lines of this battle, and it is a battle. And I can't imagine a more important place to be to defend freedom so that what we hand off to my kids and grandkids will be something at least comparable to what we inherited from our grandparents and our founding fathers and mothers. This is the fight for our time, and I'm in the middle of it. And I welcome you all to join us and stay involved and get involved. And thank you very much for that.
Well, we so appreciate it that you are at the tip of the spear for this time in history, And this inspires all of us to become activists and to join you in that fight, just as you said. So this gives me great encouragement to hear you. And I wish this had been 3 hours tonight, but we are very grateful to have the extra time. So bless you, Dr. Eastman, and your family and all the work that you are doing for the freedom of this country.